And the biggest focus all through the day has been what was observed and in fact sent out by the district court in Varanasi. It's been a big win for the Hindu Aastha. The Varanasi district court has ruled the Hindu women's petition for worship is maintainable in the Gyanvapi Mosque case, paving the way for heating on Hindu pleas on daily prayers, an ASI survey of the complex and carbon dating as well for the Shivling. So that's been the top focus, and the court today outrightly rejected the petition of the Muslim side and said the Hindu side suit is maintainable. In the suit, the 5 Hindu women, remember, sought the right to worship inside the Gyanvapi Mosque, which was challenged by the Anjuman Islamia Masjid Committee. However, the court has rejected the challenge. The court refused to consider the evidence presented by the Muslim side as the basis. Listen into the reactions coming in from both sides.
कोर्ट ने मुस्लिम पक्ष को अपना जवाब दाखिल करने के लिए कहा है और 22/9 में इसकी अगली तारीख लगाई गई है। इस जजमेंट के बहुत बड़े मायने हैं, क्योंकि जो हमारी कमीशन की रिपोर्ट है अब वो पढ़ी जाएगी, उसके खिलाफ उनको ऑब्जेक्शन देना पड़ेगा, और जो कमीशन की रिपोर्ट में शिवलिंग बरामद हुआ है अब उसमें आगे बात होगी। ये सारी महिला याचिकाकर्ताओं के लिए बहुत बड़ी जीत है।
ज्ञानवापी जो है जैसे ही मुकदमा जज किया है और स्पष्ट कहा कि जो है प्रतिपक्ष का जो है 7-11 इस पर लागू नहीं होता, वक्फ बोर्ड लागू नहीं होता, और इसमें हिंदू समाज की तरफ जीत हुई है, हिंदू समाज सनातन धर्मियों की जीत हुई है, और 22 तारीख दिया गया है, पुनः जो है मुकदमा चलता है। बिल्कुल हर हर महादेव, हर काशीवासी, हर प्रदेशवासी हर हर महादेव कहेगा, लेकिन हर काशीवासियों से, हर प्रदेशवासियों से निवेदन करेंगे कि शांति बनाए रखें।
हम लोग आगे इसकी अपील करेंगे, क्योंकि ये आर्डर हमारे लीगल हिसाब से भी सही नहीं है। हाई कोर्ट करेंगे, तो अब ये जो 22 होगी उसके पहले हाई कोर्ट जाएंगे। सुनवाई शुरू होती है तो लेकिन अगला यहाँ पर क्या स्टेप होगा? यहाँ पर कोई, वहाँ हाई कोर्ट में जो होगा हाई कोर्ट से आर्डर होगा, वहाँ के आर्डर होने के बाद यहाँ कोई होगा, देखा जाएगा।
And we have the first reaction coming in from Saeed Noori from the Raza Academy. Let's quickly listen in.
कि ज़िले कोर्ट ने जो फैसला दिया है वो मुसलमानों को सुनकर बड़ा अफसोस हुआ, क्योंकि 1991 में ये कानून बन चुका है कि 15 अगस्त 1947 में जो मजहबी मकामात का स्टेटस था वो उसी तरीके से रहेगा। उसके बरखिलाफ़ ये फ़ैसला आया है बनारस ज़िले कोर्ट का। मैं समझता हूँ कि अपर कोर्ट में ये इसके ख़िलाफ़ फ़ैसला होगा और ये काबिल समाअत ही नहीं रहेगा, इस किस्म का फ़ैसला होना चाहिए।
So yes, viewers, for the moment we shift our focus and tell you why after the district court's verdict, the focus is now back to whether or not this is a waqf property, because the courts have failed to recognize it. Now there are 3 maps that indicate what perhaps could be the truth. This one is from 1800s, and as per the British records, the English map says the basement was owned by the Vyas family. That's something that the local priests also, who have been praying in this very temple, have said. Their generations have said that this is a basement that belonged to the Vyas family. James Princeps, Varanasi collector, made this very map, and these are details that go back to 1800s, and that's exactly what becomes important. Now this is the second map, viewers, for you, and quickly take a look at the dotted lines that we're talking about. This is the internal area of the mosque that we're talking about, and this is way back in 1936, wherein the judge became the court commissioner and conducted a survey and clearly highlighted how this internal area, the dotted area that you see, is the premises wherein it says that existed a temple back then. This is the third map that we're talking about, the western side of the Kashi Vishwanath temple, and the 3 gates that you can see. This is the gate number 1. This has been produced in the High Court in 1991 by Vijay Shankar Rastogi. These marked gates are the ones for you to get a better understanding of the wall, the periphery that we're talking about, and the inner complex that is being now, that is in fact in the center of this entire controversy, and where the 5 women petitioners are seeking their right to worship. So this is pretty much 3 maps that go back to long ago, which really put things in perspective and once again make us question as to was it really a Waqf property, because the Hindu believers are extremely confident of the fact that here once existed a temple and that the portion of the temple was raised thereafter to finally construct this mosque. Let me go across to our guest joining us this evening. We have Mr. Desh Ratan Nigam with us. Also with us is Subhash Nandan Chaturvedi, who is the Hindu side lawyer, and Saira Shah Halim, writer and activist, is also with us. Let me first up go across to Mr. Nigam. Mr. Nigam, what do you make of this? Now, these are sensational details. We've put out these maps that go back to the British era, and it's being spoken of clearly via these maps. These are not Hindu believers or priests who have highlighted this. These are Britishers back then who've spoken of what really existed on this very land. But the Muslim side so far has maintained that this is Waqf property, something that perhaps the court has also not recognized so far.
In fact, with the correct position of law is only the maintainability of the petition right now. And when the maintainability of the petition is seen under Part 7 Rule 11 of Civil Procedure Code, only the government made in the plain is seen, nothing else. Whether the plain discloses the cause of action or not. And that court has found that it has disclosed the cause of action. And it has discussed 3 acts out there. The Places of Worship Act 1991, Waqf Act, and also the Kashi Vishwanath Temple Act of 1983. Now, while deciding on these 3 acts, Dharma Prasai has taken a view that the puja was continuing prior to 1947 uninterrupted and continued even till 1993 after passing of the 1991 Act. And therefore, there is no change, if at all. There has to be a change. There is no change under the 1991 Act, because this petition is not for claiming title. It is only for right to worship throughout the year, which was arbitrarily stopped by the then government at that point of time, and only permitted for few days. So the religious character could not be changed. However, all these issues are a matter of evidence, and the issues will be framed after pleadings are complete. And they have also discussed the concept of a deity. Deity in Hinduism is a symbolism of supreme being, and supreme being is reflected through our idols. And even if the temple is destroyed or idol is broken, the right or the ownership right cannot be taken away of the idol. He still owns. The Hindu law is very clear on it. There is a Supreme Court judgments on it. And therefore, the right, even if the question of title comes, that right can never be taken away if somebody, demolishes a temple and builds a mosque on it. Even under Islam, it is not considered a mosque if it is demolished or forcibly taken, but the Maulvis won't tell you all this.
Okay. Mr. Nigam, there are a couple of points, that were very clearly laid out if we go by the order copy. But if we talk about the grounds that apply here of the Places of Worship Act, that's also of utmost importance because the court says the suit is not barred by Places of Worship Act, neither is it barred by the Waqf Act. Let me go across to Syed Hasanul Haq, who's also with us on this broadcast. Mr. Haq, what do you make of this? If worship was happening here till the 1993, then who denied them the same right thereafter?
सबसे पहले मैं शुक्रिया आपका अदा करना चाहूंगा टाइम्स नाउ का। मैं शेर के साथ अपनी बातों को शुरू करूंगा। ज्ञानवापी तो एक बहाना है, ज्ञानवापी तो एक बहाना है हिंदू मुस्लिम करके भाईचारे को, हिंदू मुस्लिम भाईचारगी को आग लगाना है, देश की एकता अखंडता को आग लगाना। आप सबसे पहले समझने की आवश्यकता यह है कि आप जब पढ़ेंगे हिंदुस्तान के संविधान को, आर्टिकल 141 क्या कहता है? लॉ डिक्लेयर्ड बाय द सुप्रीम कोर्ट ऑफ इंडिया शैल बी बाइंडिंग ऑन ऑल कोर्ट्स थ्रू आउट द टेरिटरी ऑफ इंडिया। ये कह रहा है। पहले प्लेसेस ऑफ वर्शिप एक्ट क्या कहता है कि जो 15 अगस्त 1947 वहां से जो बनी हुई है यथास्थिति बनी रहे। लेकिन आप देखिए किस तरीके से लोअर जुडिशरी लोअर जुडिशरी को मैं साफ साफ बताना चाहता हूं, लोअर जुडिशरी की हैसियत नहीं कि वो आप 1991 को चैलेंज कर सके। अगर 1991 को प्लेसेस ऑफ वर्शिप एक्ट को कोई चैलेंज कर सकता है, वो हाई कोर्ट और सुप्रीम कोर्ट है। देखिए, देश में जो हालात बने हुए हैं उसको बिगाड़ने की, बर्बाद करने की साजिश की जा रही है।
आप तो जुडिशरी की फेथ पे सवाल उठा रहे हैं ना। अगर सारे ऐसे सवाल उठाने लग गए तो फिर तो लोअर कोर्ट कुछ सुनने लायक ही नहीं रहेगा सर।
सुप्रीम कोर्ट ने, माननीय सुप्रीम कोर्ट ने जब बाबरी मस्जिद का वर्डिक्ट आया था, कहा था कि हमने आस्था के आधार पे ये रखा है, आस्था के आधार पे बाबरी मस्जिद को कहा कि राम मंदिर का निर्माण, हमने कहा है हम एक्सेप्ट करते हैं सुप्रीम कोर्ट का। लेकिन जब भी आस्था की बुनियाद पे किसी चीज का निर्माण होगा और किसी को रखा जाएगा तो देश की कानून व्यवस्था लचर जाएगी। आप कानून व्यवस्था लचर जाएगी, आप समझने की आवश्यकता है। आज देश में बेरोजगारी चरम पे है, उस पर कोई चर्चा नहीं करने जा रहा है। आज आप देखिए किस तरीके से लगातार हिंदू मुस्लिम क्यों किया जा रहा है। आप जब पढ़ेंगे आपको समझ में आ जाएगा। तो 1937 में बनारस डिस्ट्रिक्ट कोर्ट ने क्या कहा था? बनारस डिस्ट्रिक्ट कोर्ट ने साफ कहा था कि मुस्लिम पक्ष और हिंदू पक्ष में बांट दिया जाए, जगहों को बांट दिया गया। वो जो वजू खाना का हिस्सा है वो मुस्लिम पक्ष में आता है।
फिर उसी के सर्वे से क्या प्रॉब्लम है?
मेरी बात
अगर ये फेथ और फैक्ट्स की बात है तो फैक्ट्स बाहर आने दीजिए। फैक्ट्स जब बाहर आएंगे खुद पता चल जाएगा कि वहां पे क्या था और उसके बाद मॉस्क बनाया गया या नहीं, और उसके बाद ये भी पता चल जाएगा कि प्लेसेस ऑफ वर्शिप एक्ट लागू होता है या नहीं। जब तक सर्वे नहीं होगा, डिटेल बाहर नहीं आएंगी तो पता कैसे चलेगा वैलिडिटी क्या है यहाँ पे प्लेसेस ऑफ वर्शिप एक्ट की। कोर्ट ने रिफ्यूज कर दिया है उस एंगल से देखने के लिए। I want Mr. Nigam to come in for a quick rebuttal, then I'll go across to Saira. Sir, point by point, we'll take it point by point. Mr. Nigam.
देखिए, दिक्कत क्या है? Ignorance of law cannot be an excuse. What my co-panelist is saying that court can't even apply that particular, can't even look into that act. Agreed, but it has applied in the facts and circumstances of this particular case, and have found that this particular case does not affect this particular issue. And therefore, their interpretation of the court is the suit is maintainable because the plaint shows cause of action. Other things will depend on the evidence, and the courts will frame issues. So it is only on the maintainability of the petition, nothing else, nothing more. And that I think every person must understand. Court will now, it has said it will look into the evidence subsequently by both the parties, and issues will be framed. And the survey report will now be admitted in the court, and people will have right to object to it, and that will also be considered by the court. So
Absolutely.
let's not misguide people. Everything is still open, but the fact remains, it has discussed very cogently. Please read that order, you will be enlightened. I'll tell my co-panelists, please read it, 26-page order. Please read it carefully. As a lawyer, let me tell you, you will have plenty of opportunity to lead your evidence in future. And it is not Muslims stand, it is Intizamiya committee only. The management committee of the alleged mosque that has come into the picture, which has challenged, and they have said Waqf code does not apply because Waqf does not apply to
Mr. Nigam, in fact, even if we go by the order copy, there are points that have been highlighted very clearly, and some of the key takeaways being that till 1993 worshipping Gauri Shringar Sthal was allowed all year long. The plaintiff is only demanding right to worship the Shringar Gauri Sthal. Sara, if you can come in. If it was allowed till 1993, then why are we even talking about the Places of Worship Act? Why are we getting into this larger debate about, whether it's a Waqf property or something else? That's certainly something that must be focused on. But these are also questions that remain unanswered.
See, I'll be very clear that it's unfortunate that the Muslim places of worship are being made the subject matter of extremely mischievous controversies that has enabled the right wing in India. And I'll be very clear, it's a complete violation of the Worship Places of Worship Act of 1991. So today, these right wing are using the law for retrogression. And I think India is a very plural, secular country. We need to understand that culture is forever evolving.
But Saira, the court has said that the foundation was laid to establish Hindu character of property. Deities existed even before 1945. It's the court that has noted all of this.
See, I'll tell you something, that law cannot be used as a device to tarnish, to break, or to uphold, a majority sentiment just because there's a certain tilt towards a particular subject. Here we need to refer to the Constitution, because that is our abiding principle. That is the hallmark of India, the Constitution. So here, if you are going to tweak the Constitution to suit your vested interest, it doesn't work like that, because here we need to adhere to the Constitution, and it is very, very clear that today we need to respect every place of worship, whether it's Hindus, whether it's Muslims, or whatever it is. Today, if we start discussing what came first, the chicken or the egg, there's no end to the discussion. Tell me honestly, because here we need to understand that culture is something that is forever evolving. And here, the right wing is trying to use the national media to narrate a certain discourse, to influence the people,
but
make
you know what? Interestingly, Saira, the court has said that no suit has been filed for declaration of disputed property as the temple. So why are we jumping to conclusions already? It says that the Hindu side plea is worth hearing. What is wrong in that? We have Rahul Ishwar as well with us. Rahul Ishwar, what do you make of this? Because though there are big question marks, on what about the origin of this land, and how is it that the Muslim side is contending that this is Waqf property and hence it could not have been maintainable. The court has said it very, very clearly, but I want to shift our focus and want you to highlight on another aspect. Does this also pave way for what will happen, let's say, in Mathura? Because the dispute is very, very similar there as well. Petitioners challenged the 1968 land agreement. The Shahi Idgah Mosque, they say, is on the Janmabhoomi land, that ASI must conduct a survey of Idgah Masjid. So very, very similar if we talk about the kind of contentions that have been put out by the Hindu side.
2 points. One, please understand that there have been historical injustices that nobody can deny. Such historical injustices have happened, and that's a matter of fact of our history. Second, as Pujaniya Sarsanchalak, Dr. Mohan Bhagavatji categorically said, we cannot take revenge of history. We cannot reclaim everything. And there is no need to search for a Shivling under every mosque. We understand and respect the apprehension of our Muslim brothers. At the same point of time, there are some temples which are very sensitive. Kashi, Ayodhya, Kashi or Mathura. These are very significant for Hindu community. And I would urge my Muslim brothers to please consider this as a Hindu sentiment, because the deities' birthplaces cannot be changed. Janmastans cannot be changed. Yes, as a Hindu, I am mindful of my Muslim brothers' apprehension, inhibition. That's the reason why, as mature adults, we need to come forward and talk to each other, bring out a consensus. Rather than a legal confrontation, we need a social reconciliation, a reconciliation with history. And these spaces are extremely sacred because they are Janmastans, they are associated with a divinity for thousands of years, and some kind of a consensus need to be fought. And Kashi, Mathura, they are very sensitive spots. Yes, there is a larger apprehension from our Muslim community's mind that can be understood. But as KK Muhammad, one of the famous archaeologists and historian, rightly pointed out, Muslims should consider talking to their Hindu brothers, and especially regarding these 2 or 3 places which are significant to them, and find out a consensus. See, this is coming from a Muslim community, from a very learned scholar who has been part of Rama Janmabhoomi. And please remember, our North Indian history, especially and pan-Indian history, has been the history of invasion.
But do you think there's ample evidence that suggests that here once existed a temple? Because we're putting out these details as well, and if you're following our screen, these are map graphics that date back to 1936. During the British time, some of the British men in fact put out this proof in the courts back then. So these are proofs that must be looked at and cannot be ignored. Rahul Ishwar.
And these are proofs of history. And one more thing, everyone, the folklore, the people there knows the reality. But I totally, I'm a Gandhian, I vouch for Hindu-Muslim unity. I respect our Muslim brothers' community sentiments. I've talked to many of their leaders. What their inner issue is, if we are conceding 1 or 2 spaces, will it pave way for larger number of spaces to go? Will it lead to riots? Will it lead to more litigation? This is a natural inhibition in their mind. That should be respected. I don't belong to RSS, but RSS being the most powerful Hindu organization, Pujaniya Sarsanchalak is on record saying that we need not search for Shivling under every mosque. but some spaces are important. There should be consensus. So please, I would request Zara ma'am and also our Muslim community to listen to that mature position. Let us engage as individuals, as mature adults, and let us talk it out, and let us bring forth a consensus.
So one can reach an amicable solution, but that's not happened so far. Let me go across to Saeed Hasanul Haq once again. Mr. Haq, क्या हम ये इग्नोर कर सकते हैं इतने सारे प्रूफ्स जो हिंदू साइड बोल रही है कि हमने डिटेल्ड सर्वे के दौरान भी देखा है कि कैसे काफी सारे हिंदू भगवानों की तस्वीरें थी वहां, सिंबल्स थे वहां, क्या ये सब इग्नोर किया जा सकता है? ये मैप जो हम दिखा रहे हैं ये कोर्ट में सबमिट किए गए हैं सर बहुत साल पहले, तो प्लेसेस ऑफ वर्शिप एक्ट की बात ही कैसे आएगी? अगर यहाँ पे पहले मंदिर था तो हिंदू साइड बोल रही है तो प्लेसेस ऑफ वर्शिप एक्ट तो मुस्लिम साइड के खिलाफ लागू होना चाहिए।
मैं आपको बताना चाहूंगा 1937 में बनारस डिस्ट्रिक्ट कोर्ट ने आदेश दिया था कि जो मुस्लिम पक्ष है उसकी हिस्सा जमीन जो है उसको बांट दी जाए वहां पे, जिसमें वजूखाना भी आता था, और जो हिंदू पक्ष था, हमारे हिंदू भाइयों की आस्था का जो मुद्दा था उसको बांट दिया गया। उसके खिलाफ दीन मोहम्मद गए थे इलाहाबाद हाई कोर्ट 1942 में, उनके एप्लीकेशन को रिजेक्ट कर दिया गया था दीन मोहम्मद के, और दीन मोहम्मद को कहा गया था और फिर से एडमिनिस्ट्रेशन को कहा गया था कि आप फिर से जाके पक्षों को बांट दें और वहां पे बांट दें। 1937 से लेके 2022 तक इनको नहीं दिखा वहां पे कि शिवलिंग है, आपकी आस्था का मुद्दा है। आज जब बीजेपी की गवर्नमेंट है जो हिंदू मुस्लिम करके यहां रोजी रोटी के लिए लोग मर रहे हैं, परेशान है, युवा रोजगार जो है, युवा बेरोजगारी से परेशान है, आज हिंदू मुस्लिम करके बांट रहे हैं आप क्यों नहीं?
ये हिंदू मुस्लिम की बात करके दिक्कत शुरू होती है सर, इसीलिए ये वाला मुद्दा तो हम छेड़ना ही नहीं चाहते। हम तो बात कर रहे हैं कि हिस्ट्री में एक्चुअली हुआ क्या था और क्या वैलिड है अभी आर्ग्यूमेंट। बट थैंक यू फॉर जॉइनिंग अस ऑन दैट डिबेट। Like Gyanvapi viewers, Krishna Janmabhoomi case has also gained traction following the Supreme Court verdict in the Babri Masjid Ram Janmabhoomi title dispute in 2019. Now in Mathura too, petitioners have sought the mosque survey. So similar cases that have come to light, whether or not we will see a similar outcome as well remains to be seen. I thank you gentlemen for joining us on this broadcast. Also thanking Saira Shah Ali.